Law Society of Upper Canada as a specialist in civil litigation since 1989. He's a partner in the Toronto firm Jean Roberge, and a bencher of the Law Society of Upper Canada and chair of the Law Society's Professional Regulation Committee, which is responsible for professional conduct and discipline. He is also co-chair of the Law Society's Strategic Planning Committee and co-chair of the Law Society's Task Force on the Reform of the Rules of Professional Conduct. From 1990 to 1993, he served as the Law Society's Senior Counsel for Discipline, in which capacity he was the Society's Chief Prosecutor of allegations of professional misconduct against lawyers. He's the author of Lawyers and Ethics, Professional Responsibility and Discipline, published by Carswell, and he's written numerous articles and publications, including the Canadian Bar Review, the Law Society Gazette, the Alberta Law Review, and the Ottawa Citizen. Howard Greenberg is certified by the Law Society of Upper Canada as a specialist in immigration law and is a member of the Law Society's Certification Committee responsible for certifying lawyers in this practice area. He's past chairperson of both the Canadian Bar Association's National Immigration Section and the Citizenship and Immigration Section of the Canadian Bar Association, Ontario. He is co-editor of the Immigration Law Reporter, the leading Canadian case law reporting series in this field. Please help me welcome Gavin and Howard.
Thank you very much, Beverley. I don't think either Howard or I want to say too much by way of preliminary remarks. I think the only thing that I'd like to say is that if you're ever asked to co-chair a Law Society continuing education program, make sure that Howard Greenberg is your other co-chair, because he'll do all the work, which is certainly the case in this program, which was Howard's idea, and he was instrumental in arranging for all of the outstanding speakers and panelists we have on the program today. And I'm going to call on Howard to make a couple of preliminary remarks and to introduce our first speaker.
First, I'd like to take a look at the materials with you, which is something which I try to do from time to time to permit you to understand what it is that you've been given to take home with you to consider. There's an article by Barbara which is loose, but nevertheless should be included in your binder material. There's also, we were fortunate enough to receive an article from Carter Hoppy, who practices immigration law outside of Canada in Dubai, on his perspective of the goings-on, ethical goings-on of immigration lawyers and what he sees from a Middle East perspective. You'll see an article which I authored on ethical issues, which will touch on a panel that Gavin will be commenting on in terms of rule changes. And you will see some information provided by Mark Orkin on solicitor-client relationship with some retainer agreements. It continues on to provide you with a copy of the new rules. The revised proposed draft rules. And you'll be able to contrast them to the existing rules to see where this Law Society is going. And then there's some interesting morning panels that will conclude the morning session, including, I guess, a discussion of courteous behavior between lawyers and administrative tribunals, courts, and visa officers. Jean Roberge, the Director General of Policy from Ottawa, is coming to say a few words. The complaints about lawyers go to him, and he in turn has to figure out what to do about you, whether to report you or not. So he's going to come and talk about what goes into the ingredients to that decision. And the afternoon workshops are kind of interesting. It's a chance where a smaller group like this gets a chance to roll its sleeves up and listen to some issues hands-on. And I'm particularly looking forward to one of these workshops. The RCMP are coming together with Enforcement Division of CIC, and they're going to bring some fraudulent documents with them from a case in which they've already obtained a conviction, a well-known case which they'll tell you about, and they're going to give us some helpful hints on how we can detect fraudulent documents and fraudulent conduct, which is probably the beginnings of lawyers becoming investigators, something you did, I guess, in your previous life. But our role is certainly expanding given the overseas fraud, and we're going to try to equip you with some of the tools you need to do that job. The first panel is basically a veterans panel. We've done this program twice before, and each time I try to choose who I view as the longest person practicing immigration law. And Mendel still says he is, Barbara. But he's in court, and Cecil's not well, and he thinks he's longer than Mendel.
Except Gary's here.
Yeah, he's not gray enough to get that status. So it falls to you, I think, to say a few words as the I guess I can't call you, maybe they call you the godmother of immigration now? If I call Mendel the godfather, I'll call you the godmother of immigration. Probably wisdom from people who have practiced a couple of decades is probably one of the most useful tools that an upcoming lawyer can gather. And this is your opportunity to talk about the pitfalls of why it is that you have a sterling reputation in immigration law and why you haven't been disbarred after 20 or 30 years. Go, please.
You should note in the table of contents, or in the introduction to my speaking, it says 30 years collective practice. I'm not quite at 30 years yet. So I think it was because Cecil was supposed to be on the panel with me, but he's not well enough at the moment to come. I did a paper, and as usual, I didn't get it done on time. That's a breach of ethics, by the way. When you say you're going to do something, you should do it. But anyways, it's loose, and I'm going to sort of cover what I've covered in the paper. What I tried to do in the paper was identify what seemed to be the most common kinds of problems that I see in immigration practice, either from clients coming to me or from, in terms of the issues we have to face, or from taking cases that other lawyers have handled, where we tend to get the cases at the last minute when the people are out of the country. And so clients say a number of things about what lawyers have told them or not told them to do, and I don't always believe it, but if in fact lawyers are telling them to do certain things or not do certain things, then there are some problems in terms of how lawyers are conducting their practice. So that's what I've tried to do in the paper. The first issue that I raised is the question of client communication. One of the commonest problems, I think, is lawyers not telling clients what's going on with their cases. Like if a lawyer misses a time limit and you need to get an extension of time, you should tell your client. If you lose a case, you should tell your client. The number of times we see people where lawyers have sat on the decision, not told the client they've missed a time limit because the lawyer didn't tell them that the case had already been refused. Sometimes it's because I think the lawyer assumes the client gets a copy, but at least with federal court proceedings, they don't get a copy. It's just the lawyer that gets it. And I know when you lose a case, I hate losing cases, but in federal court, you're gonna have to get used to losing cases, because that happens all the time in that court. It's uncomfortable telling your client that you lost a case, but you can't sit on it. The other thing that I didn't put in the paper, but I was thinking about afterwards in terms of clients, is when clients come in to see you, they say they want to make a refugee claim. I think that there's a duty to sort of canvass with them all the options available to them, not just the refugee claim. There have been cases in the past where we've seen clients who have lost their refugee cases. They've been in the refugee stream. They come to us afterwards, and they may be a very skilled professional worker and could have qualified as an independent applicant. Why put them in the refugee stream? The lawyer never bothered to look at other options in terms of it. Another kind of thing, I think, in terms of the duty to give comprehensive advice is advising people of the pitfalls in the future. One of the kinds of cases we see quite often is people, again, who've lost their refugee claims, want to make a humanitarian and compassionate application, have been on welfare the whole 4 years. Nobody ever advised them. And granted, they should be trying to look for a job on their own anyways, but I think you got a duty to tell them if they stay on welfare the whole time they're in the system, they're not going to be accepted on humanitarian grounds at the end of the day. I think they need to know that at the beginning, so that they can plan accordingly. Same with parents. If the kids leave their parents on welfare for the whole 4 years and then turn around and want to sponsor them, it's just not going to work. Immigration's not going to believe that they're going to take responsibility for their parents. But nobody's ever told them. And in fact, the being on welfare assists. They get their health coverage, they get everything sort of organized for them. But they can't be on welfare if they want to be sponsored at some point. So those kinds of things, like looking ahead and trying to make sure you cover all the bases with the person, I think that's crucial. And also, you know, if they don't have to go on the refugee stream, don't put them in it. It's the worst system in the sense of uncertainty and fear on the part of people. It's better to put them in a system that they may qualify under more easily than processing them through the refugee process. So the second issue that I sort of identified in the paper is experience. And I don't have a problem with lawyers taking cases that are complicated. I mean, you don't develop an experience and become sort of experienced counsel unless you start taking those kinds of cases and develop an expertise. What I do fault junior lawyers on who take those kind of cases is the failure to consult with lawyers that can help them sort of plan a strategy in terms of the case. In the immigration bar, I don't know about other bars, but I know in the immigration bar, senior counsel are generally more than willing to give advice to younger counsel and help them sort of figure and plan a strategy for the development of the case. But to see a case at the end of the day where it's an inexperienced counsel who clearly did not consult and has raised the wrong arguments completely to the detriment to the client, it's not right. If you're not going to properly prepare or discuss the case with someone who can help you sort of identify the issues and know how to present the case, don't take it. But because you don't do your client a service in terms of that. So, like I said, I think junior lawyers should be taking complicated cases. I think there's a very serious need in the bar to develop a more sophisticated practice. I sometimes feel like in terms of the charter issues that it's my law firm that's doing most of it, and it shouldn't be that way. We should not be the only law firm that are raising constitutional challenges. So there's got to be the development of an expertise beyond a few lawyers in that field. So take them, but you know, call me, call Lauren, call someone in terms of figuring out how to handle them and do them properly. Competence was the third issue, and I said in the outline that no one can teach a lawyer to be competent. I mean, you learn in law school that you're supposed to research if you have a case. I think the most common problems that we see is the failure of counsel to read the governing legislation and the regulations and the rules, failing to do proper legal research, failing to identify the issues, failing to prepare properly. Common examples are cases where, like, you know, you should know that you can't file your own affidavit and argue on your motion. The number of times that comes up in court is embarrassing, that lawyers file an affidavit and then go to court to argue on their own affidavit. It's just sort of a basic rule, and people should be aware of it. Another common problem is the failure, I think, in refugee claims and deportation appeals often to get corroborating evidence, to get supporting witnesses and people like that. And worse still, not to prepare your witnesses if you're going to call them. If you're going to call, I mean, I think it's essential that you go through the case with your client who you're going to call and go through the case with the witnesses. But I know from the cases, some of the cases that we've seen, that often lawyers are busy and they just tell the witnesses to show up and start asking them questions without ever telling them what the case is about properly and trying to draw out evidence to prepare it ahead of time. It doesn't work, and your client can lose a case because of that. And I think the last sort of common problem in terms of competence is the failure to meet deadlines. And I don't always see that as, I mean, I miss deadlines too. And I love Rule 7 under the federal court rules, that you can get a consent extension of time from the Justice Department. But you know, as a matter of practice, you got to try and meet your deadlines, and I think that's very important. I think that we see cases where I think it's negligent, like someone's refugee claim is abandoned because they didn't show. They say their lawyer said they didn't need to show, and then the lawyer doesn't show. That happens with consultants as well as lawyers. Those kinds of things, I mean, it's not a question of teaching people. Those are the kind of things you know you can't do, and some people do it. The next area that I kind of identified is the question of honesty, and this one, we see it come up too much for me not to believe that to a certain degree there's some problems with it in practice, that it's not just the clients. I'll give you an example. Someone makes a humanitarian application. They have been working without authorization. Their counsel tells them not to disclose it because it's illegal. On a humanitarian application, that's your opportunity to disclose fully. In fact, working, even if without authorization, makes the person's case stronger. But aside from the fact that that the lawyer thinks it might hurt them, is the fact that they've been told not to tell it. A lawyer can't tell someone to misrepresent, and that seems to be happening. Another problem is people who collect welfare and work at the same time. They have a criminal fraud. Clearly, it's going to hurt their case. If they disclose that, if people are not prepared to disclose it and resolve it, we don't act for them. We're not going to put people forward pretending that they haven't worked and instead of collected welfare, if in fact they've worked and we know it. What we do is we send them to criminal counsel and we get them to resolve the welfare problem. So they either make a payment plan with the welfare authorities to pay back, or if they can, they pay back the full amount at once. But you don't just leave it. You got to resolve it. That person is not going to, ultimately, if it goes forward on the misrepresentation, they get accepted, they're going to get deported as soon as someone finds out about it, and a lot of them are caught. More often than not from people with within their own families, because there's a family fight going on. So I think it's really important to be very careful. If someone wants to pursue a misrepresentation, they're not your clients. You can't act for them. And if you are going to act for them, you bully them. They have to disclose. It's not a question of not putting forward all the information. Responsibility to others, and I put this in because I know in my first years of practice I had a terrible time, and I still do sometimes, in terms of managing financially. And there's some sort of basic rules, like if you have a legal aid certificate and you have an agency account with another lawyer, you have an expert opinion, an expert witness who's testified, legal aid pays the account, put it in your trust account and pay from there. You can't put it in your general account, find that some payment's been taken out of your account and the money's not left to pay the expert. I know lawyers do it. I know in my first years of practice I got stuck like that several times, and I just stopped putting anything in my general account. It goes into trust. Even if it's already billed and paid, if I think that my general account is unstable enough that the money's not going to last in there, it doesn't go near it. I think for junior lawyers that's really important, because you have to pay those accounts when they're paid. You can't sit on them. Like I know we had a lawyer that owed us on an agency account. We were paid a year and a half after he was paid. And I know the problem. I didn't complain about it or anything like that, because I know he's in a very marginal kind of practice, trying to sort of make a go of it. But it's something that you've got to watch very carefully. The other issue in terms of responsibility to others is whether you have a duty to report if you see incompetent or negligent behavior or misconduct. You're kind of in a bind, because sometimes in fact, often it's a question of who's telling the truth, the lawyer that represented the person in the first place or your client. And often in those kinds of cases, I don't think you have a duty to report, because what's the Law Society going to do? They're going to hear your client say one thing and the lawyer say another thing. And there's no way of really telling what the truth was. Like, say the lawyer told me not to tell them I was working. Those kinds of things I wouldn't sort of go running off to the Law Society. I think, though, if there's a clear negligence, like it's on the record, the lawyer didn't show for the hearing when they were supposed to have shown for the hearing, I think there is a duty to report. And one of the things they say in the ethical rules is that usually, that often, if you find that there's some problem with a lawyer in terms of conduct, that it's really hiding a lot of other problems. So you may be doing the lawyer a favor. I know it sounds sort of weird, but you may be doing the lawyer the favor, because if a lawyer has mental problems or is under too much stress, it helps to have the Law Society come in and help them construct their practice, like sort of get their practice on online. And the other thing about reporting is if you're going to raise before the board or before on a reopening application or before the federal court problems with prior representation by counsel, you can't raise it before either of those bodies without having complained. So you're sort of in a position sometimes where you know the Law Society probably won't do anything, but you should at least put it on the record with the Law Society so that your client can raise the issue if you believe it's a valid issue to raise before the tribunal. The next area, you should tell me if I'm getting, I can try and go quick. I wasn't given very much time.
Keep going, take as much as you need.
Okay, the next issue or area identified was advocacy, and I characterize this as ethical in some ways because you have an ethical duty to represent the interests of your client, and that doesn't mean to sort of go into hearings and let the board walk all over you. If there is an interpreter, this is one of the things that we see all the time, if the interpreter is incompetent, for heaven's sake, say it on the record. When it comes to federal court, on review afterwards, you've waived your client's right to have a competent interpreter because it hasn't been raised. Similarly, if board members are asking inappropriate questions, and this is the hardest, you want your client to win, you don't want to antagonize the board, well, you can try and do it in a nice way. You're going to antagonize them anyways, but you've got to object. You can't just go through the hearing thinking, well, this is fine, this person's smiling at me, this is nice. They lose at the end of the day, you've got nothing on the record. And you can't afterwards raise many of these objections and say it was unfair. So I don't think, one of the things I learned through the many years of practice is it's an adversarial process. Even if they tell you the refugee process isn't adversarial, it's adversarial in nature, and treat it that way. Put your objections on the record. But the number of times we take cases to federal court and there are very solid arguments possible, we can't make them because the lawyers just smiled at the board members through the whole hearing and didn't complain about a single thing. It's essential in terms of your client's interest to represent them at the hearing, and representing means that you put your objections on the record, even though the board members are going to be upset with you for doing it. I also think sometimes we won some cases because the board members were too embarrassed with how they'd handled it in light of the objections, so they just wanted to get rid of it, so they allowed the case. I also think the second aspect of advocacy is that you put forward the whole case. So if you're filing in federal court and say you're seeking a stay against removal for someone to have a humanitarian and compassionate application considered or to review one, you don't list the whole chronology and not tell the court your client has 10 criminal convictions. If your client has the convictions, put them forward. Don't omit relevant information because you can be sure the Justice Department's going to put it forward, and then it makes it look like your client's misrepresenting their position. So even if you've got bad facts, I always think the best thing is to set it all out and address it. Just don't pretend it's not there or hope someone's not going to know. The question that someone had mentioned, courteous behavior, I think, Howard, in terms of how you cover it. You have to be courteous, but I'll tell you, it's really hard sometimes. I want to come out of those hearings and just pound the justice lawyer, or worse still, the judge. And I can't say in my whole practice that I have always been courteous. I've been at times quite rude. And I know it's wrong, but it's hard sometimes to avoid. So, yeah, it's important to be courteous. Conflicts of interest, I think, is the obvious one, and it gets covered in ethics all the time. Representing an employer and an employee can be a conflict if the employee is hiding something from the employer. Representing an investor in the investment syndicate. Representing family members. Say there have been instances where the family's making a refugee claim, the wife was raped and didn't tell her husband. Those kinds of instances. I think as a matter of practice, it's better to not represent. You can, as long as there's full disclosure, you can act for both parties if they sort of make an informed decision to do that. But, it can get messy and it doesn't help your client. So, in the case, say, where the wife has been raped and didn't tell her husband, I'd get them separate counsel and separate the hearings. I don't think in that instance that you have to disclose to the husband what's gone on in terms of the wife's past, and even though you may disclose that to the board, but because you get sort of in a bind there. I mean, clearly, it may destroy the family relationship if the husband's aware of it. But I think you get yourself off the record and you get separate representation for them. The last point that I raised here was consulting on ethics. I phone the Practice Advisory Committee all the time. If I have a problem, I'm not sure how to deal with it, phone Practice Advisory. The other thing you can do is phone senior counsel. I mean, I don't think Ken Murray would have been facing the charges he was facing in St. Catharines if he'd probably talked to a few lawyers beforehand to get advice. It's important, and to check things before you take steps, particularly if you're concerned about the ethics of it. And then the last part of my paper is when I was doing this outline of sort of what I thought the common problems were, Patricia, who works with me and types the tapes of the hearings at the board for cases that we take to judicial review, she's listed all the practice tips that she thinks are essential because she does the tapes. And she's identified a number of issues, translation problems with no objections, no objections to panel members, and when she says aggressive yet polite examination by panel members, she said sometimes it's disgusting. I mean, panel members through their tone and their facial characteristics, it may be totally intimidating the person. It won't show up in the written form in terms of the impact on the person. In that kind of instance, if the panel member is being that way, object. Then at least it's on the record. The panel member will deny it. But she said some panel members she thinks completely know what they're doing. They word things very nicely so that on a written record it looks fine, but it's their tone and their manner which is meant to intimidate the person. And then there's all the problems about people talking over each other and things like that. And conducting proceedings respectfully. So I think I'll leave it at that in terms of the issues.
Thank you very much, Barbara. In Howard's introduction of Barbara, one thing he did not mention is that Barbara Jackman is going to be this year's recipient of the Advocates Society Award of Justice, which I think is the Advocates Society Award of Justice, as you may know, has been awarded only on 2 prior occasions. It's designed to recognize fearless advocacy, often on behalf of underdogs, unpopular clients, and I think it's very much a fitting tribute to Barbara and to the Immigration Bar, for that matter, that she's going to be the recipient of this year's award next month. I'd like to introduce, if I could, thank you very much, Barbara.
Thank you.
Felecia Smith to join our panel. Felecia is a 8-year member of the Law Society's professional staff. She was in private practice and conducted a litigation practice for a number of years before she joined the Law Society. She's been one of the lawyers in the practice advisory services since the early 1990s. So she's one of the people who on a daily basis fields questions from members of the bar about problems that arise in practice, and I'm sure she has as good a grasp as anyone of the practical problems, both ethical problems and practice problems that lawyers encounter on a regular basis. What we thought we'd do on this panel is that I would start by outlining some of the rules, and particularly the proposed new rules of professional conduct that are relevant in an immigration practice. Now, I am not, as you will know, an immigration lawyer. I'm a litigator. Howard asked me to participate in this because of the work I've done in the professional conduct field, and I think particularly because of the work that I've done over the last couple of years co-chairing the Rules Task Force, which has proposed a number of changes to our rules of professional conduct that I think will be of importance to immigration lawyers as well as to lawyers in every other field of practice. Let me just say a few words, if I could, about the background of the task force. It was struck in June of 1998, about 2 years ago, and we've been working continually since then. It became apparent to us very early on, and it came as I think a bit of a surprise even to those of us who work with the rules of professional conduct on a regular basis, how badly our current rules are in need of reform. A number of the problems that we identified early on were just because of the way the rules had developed historically, which is, in short, back in the 1970s, the Canadian Bar Association first promulgated its Code of Professional Conduct, and the law societies across the country either adopted it in its entirety or married it up with their existing rules. Ontario did the latter. There were these pre-existing rulings, as they were then called, of professional conduct, which were married up with some of the Canadian Bar Association rules. So even from the outset, it had a bit of a patchwork quality to it. But what has happened since then is that as new problems have arisen, dealing, for example, with advertising, lawyers' mobility, lawyers changing law firms, and the conflicts of interest that arise there, sexual harassment, discrimination, medical legal reports. Every time a new issue has arisen, we've simply tacked on a rule at the end to deal with that without any regard to how that fits into the rules of professional conduct as a whole. So that, for example, we have under our current rules, Rule 29, which is the rule that deals with conflicts created when lawyers transfer from one law firm to another, which is a conflict of interest rule that hasn't been built into Rule 5, which is the general conflict of interest rule. Another problem is that the drafting style is wildly inconsistent because of the way the rules have developed and the fact that they've been drafted by different people. So that we have rules and commentaries. We have some rules that don't really contain mandatory obligations as much as simply exhorting lawyers to achieve noble objectives, and we have mandatory obligations in some cases that are buried in commentaries. So one thing we wanted to accomplish, which I think we have accomplished, whatever becomes of the rest of the package, is I think the new rules will be much more coherent than the current rules. We'll have one conflict of interest rule. We've reduced all of the rules to 6, and they're organized by reference to lawyers' relationships. So we have one rule dealing with lawyers' relationships to clients, one dealing with lawyers' relationships to the law society, one dealing with lawyers' relationships to other lawyers and to the administration of justice, etc. And we've tried to organize the rules in such a way that rules contain mandatory obligations for the breach of which a lawyer may be disciplined, and commentaries that are confined to explanatory material, aids to interpretation, and which provide guidance to lawyers in practice as opposed to containing obligations that you can be disciplined for if you breach them. So as I say, I hope that will be a significant improvement in the rules. Now, we also wanted to achieve a couple of other objectives. We wanted to provide lawyers with more guidance than they've been provided with in the past in some areas in which the rules have been silent. Just to give a few examples, if these rules are adopted by convocation, as we hope and expect, there will be a rule dealing with discovery abuse, and another rule dealing with lawyers' relationships with jurors, which is a subject that hasn't previously been covered by our rules. The new rules will address the difficult question of when a lawyer is permitted to communicate with an employee on the other side of a case, where there's a corporation on the other side of a case that's represented by a lawyer. A question can often arise as to when the lawyer may communicate with an employee without going through the corporation's lawyer. So we've addressed that problem for the first time. So that was another objective we wanted to achieve. We also wanted to modernize the rules by removing some obligations or language that we thought was now antiquated. In some of those cases, convocation has agreed with us, and in some, convocation has not agreed with us. The rules were drafted and circulated in April of 1999 to members of the profession, or were made available to members of the profession, and legal groups at that time. We received some additional submissions, a number of additional submissions, and I must say one of the aspects of this that I found most gratifying is that I think a number of lawyers across the province really became engaged in the process. We were very impressed by the number of lawyers who actually sat down and read the proposed new rules from beginning to end and made helpful and constructive submissions to us based on their own experiences, and I think that process has really resulted in an improved product. Convocation has now sat on 3 days to consider the major policy issues arising out of the rules. We're sitting again tomorrow and, if necessary, next Wednesday. And I hope that that will be sufficient to obtain approval in principle to the new rules, and that by the end of the month we'll be presenting them for adoption at some date a few months into the future, so that people have more of an opportunity to adapt to them. Now, I wanted to talk or identify 9 rules which I thought might be of particular interest to the immigration bar. One that I'll mention very briefly, arising out of Barbara's comments, I mentioned partly because I think it was the only one that we made a recommendation on specifically because of a representation by people interested in immigration law. We received a submission from Citizenship and Immigration Canada on the courtesy rule, pointing out, we thought correctly, that the rule that requires lawyers to deal with other lawyers courteously should be expanded to persons representing themselves, and indeed to all persons with whom lawyers come into contact in their regular practice. So that has been done in 2 different places in the rule. It's Rule 6.031 most prominently. We've amended, or are proposing an amendment, and we're not encountering any resistance to it thus far at least, to the solicitation rule. As you probably know, generally speaking, solicitation of clients is currently prohibited, except if the client you're trying to, whose business you're trying to solicit is someone with whom you've had a prior professional relationship or a family relationship, or unless the solicitation is done by means of a brochure that's marked advertisement on every page, and which isn't intended to solicit a particular piece of legal work. Our view was that that's at least outdated, and the approach that we've adopted is to change the presumption so that lawyers will be permitted to seek professional employment from clients generally. But we thought that what should be prohibited isn't the fact of attempting to obtain professional employment, which can be very much in the public interest if it results in individuals who would not otherwise be being represented by lawyers and having access to legal advice. What we thought should be prohibited were certain means by which lawyers can solicit professional employment, so that the new rule, if it's adopted, Rule 3.06, will provide that lawyers may solicit professional employment by any means unless representations are made that are false or misleading, unless the means amount to coercion, duress, or taking advantage of a vulnerable person. You still would be prohibited from attempting to influence a client to change lawyers on a particular matter, so that if you knew that a client was represented, was obtaining legal advice and representation by another lawyer, it would be improper to attempt to get that client to change lawyers, generally speaking. And there's a general catch-all prohibition against adopting means to solicit work that would bring the profession or administration of justice into disrepute. Third, I wanted to mention briefly the advertising rule. Convocation didn't go as far as the task force recommended when we debated the proposed new advertising rule last week. What we proposed was that the good taste requirement, the requirement that advertising must be in good taste, be repealed, and substituted for by a requirement that advertising must be consistent with the dignity, independence, and integrity and effectiveness of the bar. The thinking being really on two fronts. First is that the good taste requirement is far too subjective to be meaningful. As a practical matter, I don't think anyone has ever been disciplined for breaching the good taste requirement. But more importantly, I guess one could say too, the benches of the Law Society aren't necessarily the best adjudicators of good taste. But I think more importantly, we also thought that the rule should be tailored to what the Law Society is really there to do. That it's entirely proper for advertising to be regulated by reference to professional ethics and professional standards, and we thought that's what the new rule should try to achieve. The benchers as a whole, however, disagreed with us by a narrow vote, and the good taste requirement has survived. So the new rules will prohibit advertising that is false or misleading, or which may tend to bring the profession into disrepute. Will prohibit advertising that is not in good taste, and will continue to prohibit comparative advertising, or advertising which compares fees and services. That was also controversial, but the proposal that was made by certain benchers that lawyers should still be prohibited from comparing fees and services with other lawyers carried the day in convocation, and that will still be a requirement. Next, I wanted to speak about the firm name rule, and I'm sensitive to the fact that particular problems or questions arise in an immigration law practice, both with firm names and with what can appear on letterhead, so I'll deal with the two of those in turn. We considered whether we should liberalize the firm name rule. Other jurisdictions have done that. In British Columbia, for example, there's a rule that now permits lawyers to use trade names and names other than the names of lawyers who are entitled to practice in the jurisdiction. We decided not to recommend that be changed. Our thinking was that there's something professionally attractive about the notion that there's an individual lawyer with a name there who's there to represent the interests of clients. So the rule will continue to provide that the firm's name must be confined to the names of lawyers who are or were formerly permitted to practice not only in Ontario but in any other Canadian jurisdiction. So it's permissible to have the names of lawyers from Vancouver or Montreal or Ottawa or wherever else the firm practices, even if they're not licensed to practice in Ontario. The only other feature of that I'd mention is that some firms will be called Gavin, MacKenzie, and Associates. That's permitted only if there are, in fact, two or more lawyers in the firm who are associates. It's not permissive. If you're really a sole practitioner who employs a law clerk or an agent, it would not be permissible to call your firm by your name and associates. There must actually be one or more other lawyers who practice in the firm. Although in this case, the rule is not worded in such a way as to require the associates to be licensed to practice in Ontario or indeed in Canada. As far as letterhead is concerned, there still are limitations to what you may put on your letterhead. However, it certainly, the firm's name, the names of any lawyers who are members of the firm may be included. The letterhead may say also that you're entitled to practice if in another jurisdiction, if that's the case, and we're seeing that more and more often. Conflicts of interest, briefly, the changes to the conflict of interest rule are, I think, subtle. We went back and took a hard look at the joint representation rule and changed the wording of it to, I think, more accurately summarize the intention. It continues to be a very persistent problem. we considered whether we should require lawyers to obtain independent legal advice before being represented by the same lawyer on a matter. What we decided to do was to add a commentary recommending that that take place in situations where the clients are of different levels of sophistication or bargaining power, but not to require it in every case, simply because there are some cases where we felt that should not be required. Barbara touched on the issue that I think must arise frequently in immigration practice, which is where you're retained by a corporate or organizational client to represent an employee or one or more employees who may wish to obtain permanent residency status, and you're really acting ultimately for the employer as well as the employee and often members of the employee's family. And that can create serious difficulties where you're acting for more than one client. In such a situation, you have to say at the outset, explain fully at the outset, that you're representing all of the parties, that nothing can be remain confidential insofar as the others are concerned. And there certainly will be cases that you can identify at the outset as cases where the various parties should be represented by different lawyers, and that you should recommend that, and I would think where you should decline to act for more than one, depending on the circumstances. The main debate on the confidentiality rule has centered on the circumstances in which it's permissible to disclose information that would otherwise be confidential for the purpose of preventing harm to others in the future. We debated that fully in convocation a couple of weeks ago. The current rule, the old rule, provided that it was permissible to disclose confidential information for the purpose of preventing any crime. Now, we felt that was far too broad. I don't think it has had the effect of undermining solicitor-client confidentiality generally, but we certainly thought that that was a risk. Lawyers are now permitted to disclose information that would otherwise be confidential that they obtained from clients to prevent a crime, even if it's a minor crime or even a victimless crime. As I say, we felt that that was far too broad, and that solicitor-client confidentiality would be strengthened if that were narrowed. Now, while the task force was considering the problem, fortuitously, the Supreme Court of Canada decided the Smith and Jones case, which you'll recall is the case arising out of British Columbia from Vancouver, in which a person accused of serious crimes of violence against prostitutes in Vancouver made statements to a psychiatrist retained by the defense counsel that made the psychiatrist very, very troubled about the risk of harm to others in Vancouver. And the psychiatrist brought an application through counsel to the court for permission to disclose the contents of the interview to the extent necessary to the police to prevent harm to others. And the Supreme Court of Canada agreed that it was appropriate in the circumstances of that case that the psychiatrist, who was really in the same position as defense counsel would have been if the communication had been received from the client directly by defense counsel, that it was permissible for the psychiatrist and by extension defense counsel to disclose information that would otherwise be confidential for the purpose of preventing that harm. So the Supreme Court of Canada articulated the test which we felt we should adopt in Ontario. So Rule 2.033 now will provide that it's permissible to disclose confidential information to the extent necessary to prevent imminent risk to an identifiable person or group of death or serious bodily harm. And there is a rider to the effect that the lawyer must not disclose more information than is necessary to accomplish that purpose. Now, the task force would have gone slightly further than that because we drafted two rules that would have also made it permissible to prevent the same imminent risk of harm, even if the harm wasn't physical, if it arose, for example, because of fraud. And we would have permitted disclosures to be made, and we were lobbied by the family law bar to do this, to permit disclosures to be made to prevent not only fraud but harm to children or other vulnerable people, even if it wasn't the kind of serious physical or psychological harm contemplated by the Smith and Jones case. Convocation decided that we should not go that far, since the Supreme Court of Canada has defined the circumstances in the way that they did in Smith and Jones. The exception should be that narrowly tailored. So the justified disclosure rule is much, much narrower than it formerly was. It certainly will have the effect, I think, of protecting the sanctity of solicitor-client confidentiality and privilege. It may, however, have the effect of bringing the profession under attack in circumstances such as those that have prevailed in some American cases, for example, where lawyers have been aware of serious continuing frauds that have victimized people and caused them to lose a great deal of money. And there's been some criticism of rules that permit that to happen. Let me move to two other final points, and I'm sorry I've been speaking too long. Supervision, Rule 5.01. This again, I'm sure must arise often in an immigration practice where people deal with agents abroad and paralegals or law clerks who are able to do a great deal of the work that must be done in an immigration law practice. The rule will continue to provide that a lawyer is responsible for the work done by agents and clerks and must supervise them adequately to ensure that that occurs. And a lawyer must also ensure that legal advice is not provided by persons who are not qualified, qualified in the sense that they're licensed to practice to provide legal advice. And finally, I wanted to talk about referral fees and fee splitting. This is another area in which the task force made a recommendation for a fairly dramatic change in our rules of professional conduct, and Convocation has agreed and has decided in principle to adopt the rule that the task force recommended. Fees may still be divided between lawyers, as has always been the case. The difference between the old rules and the new rules will be that referral fees will now be permitted between lawyers in certain circumstances. The policy rationale behind that is to encourage lawyers to refer work to lawyers who are best qualified to do it, so that under the rule, for a referral fee to be permissible, the referral must be made for the purpose of referring the client to someone who is qualified to do it because of experience or expertise, and the referral fee must be reasonable, and the client must be informed of it and consent. But subject to those restrictions, referral fees will be permitted under the new rules between lawyers. They will not be permitted between lawyers and non-lawyers, however. Now, recognizing that this is a major change, the task force's recommendation was that we should monitor the experience under this rule. British Columbia and Saskatchewan have had similar rules over the last few years, and the reports we received from those law societies have been to the effect that, that they have been working well. There have been no unusual problems that have arisen because of them. One suggestion that was made to us was that the law society should specify the amount of the referral fee, or the percentage amount of the referral fee, to avoid shopping around for the lawyer who will pay the highest referral fee as opposed to the lawyer best qualified to perform the task. Another suggestion that was made to us was that referral fees should be permitted only if they're to certified specialists. And those may be directions in which the rules evolve in due course. We didn't think the Law Society certification program was such yet that that restriction should be built into it. it may be in due course, as I say, and perhaps in due course we'll find that it's necessary for the Law Society to specify the percentage. We didn't think it was necessary or advisable that we do that now. So those are some of the new rules, or proposed new rules, that I hope will be in effect by the end of this year, that I think may bear on immigration lawyers' practices.
We put a fact situation in the materials, which can be found before the table of contents, to try to bring down to earth some of these rules you've talked about in terms of, I guess, new and seasoned practitioners who have to make some organizational decisions. I wonder if both maybe you and Felecia can comment maybe on the simple fact situation to the extent that it's covered your material, and we can carry on this morning into Robin's section to the extent that other sections pertain to it. But in the fact situation, John Smith appreciates the highly competitive nature of a diverse immigration practice, and he's very entrepreneurial. So he's called his firm John Smith and Associates, which I guess we'll take from your discussion this morning, that there better be some associates around besides John Smith.
Yeah, and they have to be lawyers.
And his head office, clerical ownership, will be in Toronto. Now John's deciding the structure of his relationships. And he realizes that all his clients are obviously not in Canada by definition. Well, many of them aren't in Canada by definition, and therefore he's going to have to get some bird dogs out there of some kind to feed the pipeline, because he's very entrepreneurial, and John may be misfortunate in that he considers himself first to be a business person and second to be a lawyer. And so he wants to open up these local offices of sorts, and I guess stop me every time I make you uncomfortable. But still permit me to speak. So John's going to open up John Smith and Associates in Moscow, of which neither John nor any of his Canadian staff would be occupying that office. Or John would have a local agent open an office, and all through the waiting room you would see John's brochures. He needs the local agent to feed the work. And so whether he wants to represent himself and put his own reputation out, and I guess a more seasoned lawyer would put his own name out, and a more junior lawyer would rely on the reputation of the local agent. The offices are going to be itemized on John's letterhead, because John, from a business perspective, sees the strategic advantage of listing at the bottom across the letterhead offices in Dubai, Moscow, Hong Kong, New York, da-da-da-da-da. Of course, John doesn't occupy physically those offices, and subject to your comment, he may have somebody from his office in Toronto there from time to time, but it's highly unlikely that any practitioners have Ontario practicing lawyers, part of the Ontario firm, in Moscow on a regular basis. He's decided that to the extent he's using local representatives, he's going to characterize them as his agents, because he wants to enjoy their goodwill in the local marketplace, whatever that might be. And he wants to promote this firm in a more robust way by advertising, and I can tell you that if it's the you all can help me out on this if I get the newspapers wrong, but I'm trying to, in Pakistan, I'm trying to remember the name of the Pakistan newspaper. If you open it up, it's got more, I'm sorry?
Dawn.
Okay. Well, if you open it up, you'll see more Canadian advertisements, which must be very confusing. Once you get past the beautiful Canadian flags and whatnot, you can't figure out who the agent is and who the lawyer is anymore, never mind the guarantees of getting your money back and the rest that goes with it. Advertisement in Pakistan. But John wants to get this advertising material out there. Now, he's heard all about your speech, and he knows that everything's been liberalized, and he's just going to say he thought that you'd loosened up the rules. He really hasn't read the commentaries very carefully, nor does he really want to. if he wants to put this into effect. Now he has to define what he's going to do with this agent. He's got a very interesting dilemma, you see, because the agent's the bird dog, and he or she meets the individual and has the initial conversation, which John has no control over that conversation whatsoever. That conversation could be that John is the best lawyer in Canada. He's the only certified lawyer in Canada who can do the job, and that's why it's worthy of a premium, double the amount. Or this agent could simply be collecting documents for John, saying he would forward them to John and let John consider them. But John has no relationship over that, has no impact over that relationship. And probably of more concern is the flow of money. It's highly unlikely that the agent is going to sign up the client and the client's going to send his or her monies directly to John's trust account. Those monies are going to have to flow in some fashion to John through this agent. And the agent may in fact be retaining the monies in the local jurisdiction because, as we all know, the agent's worried about getting his or her share of the cut, which I guess raises other issues as to how that relationship can be devised. In fact, what that agent's saying is, look, I'll put the ad in the newspaper and I won't charge any money for it. I want 25% of your fees. And I might want another 25% if I have to handle the documents, translate the birth certificates, figure out the education institutions are real or not. I mean, if you're really actually making me work for the money, I want another 25%. Now, if you want to set up business and do business with me, these agents are saying worldwide, this is how you have to do business. What do you think?
Gavin, you can start. Actually, these are, needless to say to the audience, real situations, and we get these calls before people start up their practice in practice advisory, which is now called advisory services, because lawyers are concerned about not breaching the rules and setting the practices up properly. I'm not sure where to start with the question, actually, Howard, and not to repeat what Gavin's commented on already. I'm going to try to just deal with some issues that Gavin has not commented on with respect to the present and the future rules. In terms of advertising, I don't know that there's necessarily a problem with the lawyer advertising with the consultant as long as the arrangement is properly described, so that the lawyer doesn't appear to be an employee of the agent and the lawyer's, the matters that the lawyer is going to undertake are clearly defined or clearly explained in the ad. And I'm not an immigration lawyer, so please excuse me, but what I would assume happens is that it appears that the lawyer is working for the consultant, and that's quite the opposite of the way the arrangement should be structured. So, and because Gavin said that good taste is still available in the new rules, one ought to consider whether the advertisement's in good taste, because the Ontario lawyers are still bound by our rules, and they're still bound by the bylaws in Ontario, and the Law Society has jurisdiction over you. And I know that doesn't probably sit very well, but you have to make sure that you abide by the rules and the regulations here in Ontario. So I don't know that there's any problem advertising together, but ensure that the arrangement is properly described. And in terms of arrangement with the consultant, and I believe our next speakers speak about this, but the arrangement ought to be clearly defined in writing, as far as I'm concerned, with very specific explanation as between you and the consultant as to what the consultant's doing or not doing. You're the one that's in control, not the consultant. You're still the lawyer that's practicing law. We oftentimes recommend, and Gavin, you can comment on this, that the lawyer structure the arrangement such that it is the same relationship the lawyer would have as if the client was in Ontario. They have a retainer agreement with the client. If the client and the consultant want to exchange fees, and I see some frowns in the audience, they can do that separate and apart from the lawyer. The lawyer bills the client in the normal course, and the lawyer receives the retainer in his trust account in Ontario, for example. If not, many of the arrangements will enter into the fee splitting under Rule 9 of our current Rules of Professional Conduct. I can tell you also that we do get many of these calls when there is a problem with the fees, and some of the lawyers in Ontario are having problems getting their money, either from the client or from the consultant. And at that point in time, it becomes really difficult, because when we ask lawyers, what's your arrangement with the consultant, or what's the understanding that you had, or what does the client think the consultant's doing and you're doing, many times the lawyers say they don't know, or they're not sure, or it was never clearly defined. So it's absolutely urgent or absolutely mandatory that you define your relationship with your non-lawyer. The delegation rule, again, I think is important. If you have offices worldwide and you have a consultant in your office with your name on it, arguably you're responsible for what that consultant does and whether they're an employer or an agent. And if something turns out to be fraudulent or there's a problem, it's you, the lawyer, that's going to be responsible, notwithstanding the fact that the office is not in Ontario. You can't divide a fee with a non-lawyer, nor can you accept a commission, nor can a lawyer accept a commission from a non-lawyer, unless the client consents and the client is clearly advised about that. That's under Rule 9(8), under hidden fees of our current rules of professional conduct. Gavin, that's staying in the new rules, I believe. So you have to be very, very careful. The problems usually arise, of course, when there is money or there's a lack of money. So make sure your relationship is defined, and make sure it adheres to what is currently Rule 9 of the rules of professional conduct. I'm not sure, Gavin, if you want to make other comments.
I don't think so.
So what if I try to outsmart you? And then what I do is I say, the agent's my client. So I say, oh, I don't know, what's the difficulty? I'm acting in Moscow, and he in turn has people that he has entered into business relationships with, and he's asked me for advice on those. Have I circumvented all the issues?
So you render your account to
The
agent?
Sure. Well, the agent's not the agent. The agent's the client. He simply says, now you act for me, which means you keep your mouth shut, subject to what it is I ask you, direct you to do, because I am now instructing you. And I'm bringing people to you, and I am their representative. And these people are people in which you're going to assist in immigrating to Canada.
It's pretty hard for you to take the position that the people who are immigrating, on whose behalf you're obtaining a visa, aren't your real clients.
Okay, and so in that regard, they too should have a retainer agreement executed independent of the Moscow client? Is that what you're saying? Is it because there's a fiduciary duty to these people, or do you think that in law there is a solicitor-client relationship with each of these individuals behind the Moscow agent, and they should be in turn entering into agreements with?
The latter. I mean, I don't see it as being different in principle from the situation where an employer approaches you, asking you to act for prospective employees who wish to immigrate to Canada.
Okay.
I mean, I think the employees in those cases are your clients if you're obtaining visas for them. Maybe the corporation is too. The ordinary course of the corporation would be as well, as would be perhaps the agent on the structure you're trying to set up.
Howard, that question actually comes up a lot, because lawyers that do agency work for lawyers oftentimes take the stance that the lawyer they're doing agency work for in any area of law is their client. And I agree with Gavin. It's not the lawyer that needs the assistance. It's not their problem. It's the client's problem.
So let's talk about the flow of cash. The client in Moscow is paying his $10,000 US to, just making up the amount. Get everybody out to Moscow next flight. He's paying that money directly through to your trust, through the hands of this agent, directly into your trust account. I mean, how would these law societies supervise the relationship otherwise, or the accounting? The monies have to flow through to Ontario and be in an Ontario trust account virtually immediately upon entering into the relationship.
Entry into the relationship with the client,
Yes.
and the consultant is receiving the funds.
Well, typically, the lawyer, John has no relationship with the client. He doesn't even know who he is. The bird dog's got the victim. Is bringing him forward, and he's got the cash. The money's got to come, but typically, the consultant says, I'll take my split or hold on to it. But what would our view be from this side, is that money should have flowed through and been dispersed out properly with a proper account rendered?
Absolutely. I mean, again, everybody's guided by our bylaws and regulations, and that's in fact the way it needs to be structured.
Good question up here.
What would be wrong if Howard's stealthful scheme one step further, and you were retained by the agent overseas, and all of the contracts were signed between the potential immigrant and the agency, all of the representations to the visa officer made by the agency. All the agency is doing is asking you for legal advice as to whether or not this particular individual qualifies under the independent program or would qualify as an entrepreneur. My view, that wouldn't be any different than if you were retained by a corporation that was involved in, say, import-export of goods or commodities, where you're not acting for the individuals who are involved in the import-export of commodities, but are simply acting for the company that represents those people. And I don't quite see the analogy, I don't quite see where the analogy would be different. It's always something that I struggle with.
Yeah, I think it depends on what you're really being retained to do, it seems to me. I mean, if you really are being retained by an immigration consultant from another country to provide it with advice concerning Canadian immigration law and to charge for your services, and that the consultant relies on your advice concerning Canadian immigration law in order to assist prospective immigrants in applications in matters in which they don't have to be represented by Canadian lawyers, I think on those facts you'd be fine. I think you're properly charging your real client for your own legal services. I don't think you could, disguise the relationship that Howard's been talking about to make it appear as if that's what you're doing, if that's not what you're really doing. If what you're really doing is being retained to act for potential immigrants and your real clients are the immigrants, then it is.
The truth of the matter is that in all likelihood, the local agent doesn't know anything about the immigration. It's going to rely solely on you as to whether or not this person qualifies, or whether this person has the necessary takes to get the approved. So, to me, anyways, the line is very important.
To bring clarity to your fact situation, what's the next step after your opinion? Are you going to be involved in the preparation of the application and filing it with a submission, or is your role complete at that point?
No, you would be involved in every step of the way. So after you render here, or after you render your opinion,
Yes.
then the person sends to you, the consultant then sends to you a draft submission to the visa office. And then you review it, and you amend it, and you send it back to them, and then they forward it to the visa office under their name. So in effect, you're really controlling the process each step of the way.
But your name doesn't appear in the application as the legal
It
representative.
only appears in your account to Molotov.
Is the client, the applicant, relying on your advice directly? Does that applicant know about you?
Not necessarily. But it's no different than if I'm an importer of tires, and I hire a Russian company that has expertise in import-export law, I work for the Russian company as their counsel. Somebody's going to have to explain to me what the difference is. That's my concern. It's always been my concern.
Can you be a phantom lawyer?
Isn't it a limited retainer? What he's describing, isn't that a limited retainer?
Yes, I think so. I mean, that's,
Well defined what the limits of this retainer are, you can be retained for a limited purpose.
no, you clearly can, and that's what I think I meant previously when I said if that's what you're really being retained to do is provide advice to the consultant, there's certainly nothing wrong with that at all. I think it is a retainer limited to a particular purpose, which is entirely permissible. What do you think, Felecia?
I agree with you. We're actually doing some research into who is the client because it comes up in various situations, and it is a difficult question to answer. And it's I believe a legal question as opposed to an ethical question. And so stay tuned on the Law Society website. We'll have your answer for you.
What about the opposite, where you train someone to sort of act as a paralegal, and they go to the other country, and they actually do work under your direction? They collect the necessary documents and stuff like that. You can pay them, probably on a disbursement, can't you, for having done work
Absolutely.
in respect of preparation?
Yes, absolutely. And you can, we changed the language of the proposed rule governing the prohibition against sharing fees or paying referral fees to non-lawyers, to take that into consideration, so that, you know, there's nothing, you would be perfectly entitled on the facts that you outlined them to pay a bonus to an employee who's been particularly effective or productive.
Or pay for times 10
Yes,
in terms of veterans?
yes. We're running a little bit late, I think about 15 minutes late. Perhaps we should take the break.
Okay. If there are more questions, I guess you could email Gavin at his office. Well, actually, Felecia, maybe this is probably a wonderful opportunity to gather more inquiries for...
And or call advisory services, because it is strictly confidential, and whatever you say to us does not filtrate through the Law Society. And we also have a mentor list in immigration with Barb's on it and Howard's on it. We've got some very prominent immigration counsel to help as well, and they've been most helpful. So please feel free to call.
Let's take 10 or 15 minutes for some coffee. Thank you.